Mass Torts Director, what does that person do?
Yeah. Great question, right? Sometimes one of the really cool things about our firms, what makes the decision for us is whether it's a good cause. I think that's one of the reasons I really like being at Lanier in particular.
And do you then go to like a secret meeting in Mark's house and you're like, these are the ones?
Absolutely. Yeah. No, there's like a password to get to the door and everything.
Back on the Jon Marc Podcast, we have today a very, very special guest, the Mass Torts Director, Rebecca Phillips of the Lanier Law Firm.
Hey.
Thanks for joining us.
Yeah, thanks for having me. I appreciate it.
We are here at MTMP in Las Vegas at the Bellagio. Rebecca agreed to join us on this podcast. We've been talking for a while, been working together for a while, but actually getting the opportunity to sit here and dive into probably a little bit more technical topic than people are used to. We're going to talk about Bard PowerPort. We're going to talk about the life cycle of a mass tort. Appreciate you being here with us today.
Yeah, thanks again for having me.
Couple questions for you.
Okay.
Mass Torts Director, what does that person do?
Yeah. Great question, right? This is even internally in the firm. When we have meetings, I'm kind of explaining it sometimes. There's really two big parts to the job. One part is vetting cases when they come into the firm. So as you might imagine, lots of people like to work with Mark Lanier and the Lanier Law Firm team. And so people approach us all the time with new ideas and new cases. And if it's a mass tort case, then I'm the person who will look at it. A little bit of secret if you don't know me well, I'm a huge nerd. Went to law school at Yale, so I like to get into the nitty-gritty and the details and look at things. So that's part number one of my job. Part number two of my job, not nerd side of the coin, is networking with people who refer us cases. Making sure that they feel well taken care of, making sure that we're doing a good job there, and yeah, talking to people like you.
I'm assuming you guys get a ton of stuff, or you personally get a ton of stuff put across your plate. What does that process look like from a vetting? And do you then go to like a secret meeting in Mark's house and you're like, these are the ones?
Absolutely. Yeah. No, there's like a password to get to the door and everything.
The Ouija board.
No, it's actually pretty informal. It depends on the process, right? I mean, sometimes we see cases that come in that they've been through trial and we know it's a viable case, and all we got to do is make some decisions about whether it's the right thing to do, whether it's a good business decision, all that kind of stuff. And we go, it's people who we're friends with, who we've worked with, we know them. And then other times it's somebody calling who says, I've been seeing a lot of these kind of cases come in. I don't know if it's a really good mass tort or not. And we have to look at it. We have to look at the science. And so me. Yeah, I will look at the science and I'll say, is this viable scientifically? Is there a doubling of any risk? That's one of the threshold questions. I'll look at, do we have personal jurisdiction in the case? I'll look at, are there any preemption issues? I'll look at a number of things to try to figure out just practically whether it's viable. And then I'll look at it as a business decision, right? I mean, you guys know you do mass torts. So obviously, if there's going to be 25 cases out there, then that's not a great mass tort. Or this is a great case, but the defendant is going bankrupt and I'm not going to be able to get but a quarter for each of my clients. That's not going to be worth it for anybody. Sometimes one of the really cool things about our firm is what makes the decision for us is whether it's a good cause. And I think that's one of the reasons I really like being at Lanier in particular and working with Lanier in particular, because he really sort of puts his money where his values are. There was a case, for example, one time I wanted to bring into the firm. It wasn't a mass tort. It was a constitutional 1983 case. And I was right on the edge of trial. They needed trial counsel and I wanted to go try it, but it was going to be a hard case. And we were going to have to put up probably $200,000.
Not a chunk change.
Ended up being more to go try it, just to pay for the experts, to pay for the trial team living in California while we tried this case, to pay for all of it. At the end of the day, Dara said, it's the right thing to do. So we're going to go do that. And we won and it was great. And we ended up making money off the case. But you don't always know that on the front end. So
I feel like that's a lot of pressure, the position you're in of vetting those. Because not only is it a lot of resources from the firm's perspective, but if, I don't know, your firm does have a certain weight to decisions that are made, that if you say you're going after it, people might start advertising and sending them to you.
Exactly.
So you can have a lot of wheels in motion by saying that you are going after a particular case.
Exactly. And luckily, I should say that it's not just me.
Yeah.
I will vet it. I will make my recommendation, and then our firm managers will weigh in on it. And there's a lot of experience in that room when, things are being discussed to make sure that we're doing the right thing.
What is a case that came across your desk that you vetted and you're like, this is not one that we should go after?
Oh, man. Okay. So do y'all remember the eye drops case? The adversary eye drops case? So when those came in, everybody was super excited about that because the injuries were horrible. And of course, what was going on in that case, of course, something needed to be done. This needed to be corrected in the market. But when I looked at the law, I really thought, this is going to be most viable in California, because California is one of the few states where you can hold the distributors accountable based on just what the underlying law is. And everywhere else, the main manufacturer who was going to be at fault, I don't know if we're going to be able to get a cent out of those people just because of the way that the law worked and because of where they were located and all sorts of things. And so at the end of the day, we ended up taking only California clients and helping those people. And we were able to help those people. That was a decision that if we hadn't made the decision to keep it really narrow, only represent these particular clients, we would have gone out and got, as many cases as we could and not been able to work with it. So.
Yeah, that's a pretty low volume mass tort.
It was very low volume. And I think there wasn't even centralization. Yeah. But we went after the California cases. We got some California cases and we helped some people.
You're in leadership on Bard, right? What was it about that case that checked the boxes for you? You're like, this is one that we really should be investing time, money, resources in.
The story on the Bard case is a guy who I learned to be a plaintiff's lawyer under. His name is Alex Barlow. He is my mentor in plaintiff world. I came over from the defense side and I did not know what I was doing. I just remember this one time on the defense side, when you get requests for production, you object to everything. You give them nothing, right? You just object to everything. 25 pages of objections only. We're giving you nothing. They asked the plaintiff for some discovery in this case that evidence did. And I wrote my 25 pages of objections. We will give you nothing. And Alex came into my office and he said, we do things differently on the plaintiff side. We're going to give them basically everything they're asking for because we don't have anything to hide. So I learned real quick that it was different. And Alex taught me that. He was a great mentor. And he approached me about this case. And he told me about the science and he told me about the team that they were putting together, the injustice that's happening right now with people who are really vulnerable. This case concerns cancer patients. They are so vulnerable. And I can't imagine, just as the worst possible time in my life when I'm fighting for my life, having to also on top of that deal with a life-threatening injury.
From a device that's supposed to be helping you.
From a Trojan horse that is supposed to be helping me. That's exactly, what's happening here. So that's how the Bard case came to us. And when we read it all out, it looked good. It looked like something needed to be done. And here we are.
And so you are on leadership for that Mass Tort.
Yeah, I'm one of the co-leads. There's 3 co-leads in this case, and I'm one of the co-leads. It's my first experience being a co-lead in a litigation. There's a lot to learn. We've got about 20 or 25 firms participating in this. And, knock on wood, so far, so good. I think we're doing all right. There's about 2,000 cases filed. We're about to get the case-specific briefing behind us, and we're about to go to trial in 2026. So
the first bellwether.
Well, actually, 6 bellwethers will happen in 2026.
Woo.
Yeah. So if you're not familiar with this tort, the signature injuries are a fracture of the catheter, which can usually go into the patient's heart. If it embolizes, it'll go into the patient's heart, do some damage. They have to have it removed. Scary situation. The catheter can get infected, and when it does get infected, it's a bloodstream infection. At the very minimum, requires removal of the port which the patient needs for chemotherapy typically.
Is because it's supposed to be close to their heart so that the medicine can circulate through the blood.
Yeah.
Right.
So there's that, or the port can thrombose. And when you get thrombus that embolizes, you end up with pulmonary embolism, also life-threatening. So these injuries from these ports can be very serious at the time in the patient's life when they do not need to be dealing with serious complications. And the most remarkable thing about this case to me is that since at least, and this is being generous, but since at least the early 2010s, there has been a solution to these problems. And Bard and Becton Dickinson never implemented the solutions to those problems. It's really, in my opinion, a factor, just the fact that they control, since about 2006, they've controlled 70 to 75% of the port market. And if you just limit that to the United States, it's even more. They just don't have an economic incentive to make these ports better.
They didn't learn their lesson from hernia mesh?
Apparently not. Yeah. I'm not an antitrust lawyer, but I do know that when a company controls more than 70% of the market for a given period of time, you start to ask questions about that. And a little surprised those questions haven't already been raised here.
With many mass torts, we see this cause and effect scenario. Right? In Bard, it's if you have the PowerPort, it gets infected or it moves and it or breaks and then it causes X issue, right? There's a lot of other either medicines or medical devices that are known to cause issues. For those people who are listening who maybe are not as familiar with mass torts as you are, what makes Bard PowerPort specifically become a consolidated tort versus all these other drugs that have these side effects and issues that aren't necessarily things that people could file lawsuits for?
A lot of the times what you're talking about, I think, is a failure to warn claim. If the drug that you're talking about, has a warning that, for example, this particular drug can cause a seizure, and then it does cause a seizure, you may even still have a lawsuit in that case if they said, seizures are rare, don't worry about it. But actually, 50% of the people who take this drug have a seizure, right? So that's a failure to warn case. This case is a little bit different. There is a failure to warn aspect of it, but the case that I'm most focused on is the defect aspect of it. You can't outwarn a defect. A product, if it's supposed to do a thing and a consumer expects it to do a thing and it doesn't do the thing, if it's unreasonably dangerous, then that is a defective product.
Yeah, imagine the product had a label on it, will probably break.
Exactly. Well, and look, in this case, it's a coin flip as to whether your device breaks or not.
Yeah.
I was talking to one of my colleagues the other day saying, they made these cancer patients play Russian roulette. And then I thought to myself, no, it's worse than that. There's a study out there, it's the Khalid study, and it says that 60% of these devices fail, either by fracture or by infection or by thrombosis. So it is truly, your odds are worse than a coin flip as to whether or not your port's going to fail. And if they can fix this problem, they need to fix this problem. They can fix this problem.
The product that controls 80% of the market fails 60% of the time is insane.
Yep. And if you look at the numbers, there's just a crazy amount of these cases out there. I'm going to try to remember it off the top of my head. It's something like 400,000 of these ports are implanted every year. If Bard controls 70, and that's conservative, I think. If Bard controls 70 to 75% of that market, you can see how many that is. And then if 60% of them fail, I think you end up with a number like 180,000 or something. And that's per year.
I didn't go to Yale, but I think that math is pretty close.
The maths. Yeah.
It's a serious problem.
A lot.
And
per year.
There are studies out there that will say that this is a problem that doesn't just cost, it's not just hurting the patient physically, but it's actually costing the U.S. healthcare system billions of dollars every year because of the cost to, I assume, Medicare to treat these kind of things and the product being defective. So it's costing a lot of money. When I say billions of dollars, let me be clear. I believe the study that I'm thinking of is of all central line catheters. And I think ports may only be, 25% of central line catheters. And so 25% of billions of dollars is still a huge problem. And that's not to mention, I think that same study says that it costs something like 25,000 lives every year. That's insane.
it causing more of an injury to someone who's already having cancer, then you have to try and treat that injury on top of them already having cancer. Just has to make exponentially more expensive to do so as well, to remediate the issue.
It's not good.
Is there an appropriate vetting process in place so that devices like this don't make their way to market?
Yeah, so that's a great question. For medical devices, there's something called the 510K process, and you may have heard of this. All right, then we'll talk about it a little bit. We'll break it down. So,
Mark's like, yeah.
So when I talked about preemption earlier, if device goes through what's called the pre-market approval process, PMA process for short, simplifying here, but what that means is that there's been some clinical research done. The FDA has looked at it. The FDA has said, yeah, we are going to approve this device and say that it is safe and effective, right? Generally. But if it goes through the 510K process, well, that says there's other devices like this on the market.
I've heard about this.
There's other good stuff like this on the market. And the company is saying, on my honor, this is just like those other devices.
Yeah.
And so you need to go ahead and clear, not approve, but clear this device to go out onto the market. And so these devices were cleared through that 510K process and never formally approved by the FDA.
I'm going to be careful with my questioning here. Did Bard claim, or does Bard claim, that they appropriately vetted and tested the device?
Of course they will. Yeah, of course they will. They will say that these devices are safe and that they save lives and that they need to be on the market. And we're not saying that ports need to be pulled off the market. That's not our case here at all. Our case is you haven't updated these catheters for more than 20 years. And can you imagine other medical technology that has not been updated for more than 20 years when it could save lives to do so? It's insane.
You don't have to update it if it's working, but if it's failing 60% of the time, maybe upgrade it. In Bard, you are one of the co-leads. What are like the roles and responsibilities that you have?
Make sure everything goes well. Don't fail, right? So work with all the other attorneys who are working on the tort and to be the person at the end of the day who's responsible for everything. So there's 3 of us who are standing up in court at most of the status conferences with the judge and answering to the judge for everything that goes on the case, arguing everything that's going on the case, just kind of generally being responsible for everything at the end of the day. We're in front of Judge David Campbell out in Phoenix, Arizona. He's the former head of the Federal Rules Committee. He is sharp and he is fair. I laughed really hard one time in court, and I shouldn't have, because he came in and he goes, I haven't had much time to review the parties' papers, so, let me make sure I've got this right. And then he proceeds to know the papers better than the parties who wrote them. Like, he's very sharp. He's very good. He's very fair. We really enjoy being in front of him.
Of the 6 bellwethers coming up in 2026, are any of them your cases?
Yes. So we have 2 that we are going to be trying. One of them is a fracture case. Mark will be trying that one. We really love our client in that case, and she's been very injured and very wronged. So we're excited to go get some justice for her. The other case is a defendant's pick. I'll put it that way. And I'm going to try that one myself. I'm going to try it with a team of a couple other people who I really love. But yeah, I'll be doing that one. So it's exciting.
The firm is in a lot of mass torts. How did you then decide to try to be on leadership for this one versus other ones?
We typically like to be in leadership. If we're going to be in a case, our specialty is litigating it, right? Our specialty is going to trial. And so I know a lot of firms will just get cases and they don't want to be in the fray and they want to wait until the end and then get involved in the settlement process. That's not our MO. We like to be in the fight, in the fray, and making sure that what's getting done is getting done well, so that when Mark wants to try these cases at the end of the day, it's ready for him to just pick up and run with it.
I personally like the Bard case. It's very clear what has happened. It's a cohort of people that are all very similar, that all have had the same issue. It's a very, very clear mass tort. I think it makes it just very linear and clean for firms who are looking whether or not they want to be involved in it or not. For firms that are local and maybe every once in a while decide to invest in a mass tort, would you recommend that this is one that they should consider getting involved in? Do you have to be more experienced in order to move into this? Because it's not just simple, like take this drug, had this problem.
I do think that this is an easy case to get involved in. And there's so much calculus that is going on in my mind right now as to whether or not this is a tort that people should get involved in. It is hard for me to say what that calculus is for everybody, but I do think it's a good case. I'll tell you this, the one thing that I think people are a little bit scared of in getting into this case is that a lot of the injuries are infection or port-related thrombus. And I think in some other mass torts like TBM, when people saw an infection, they went, that's low value maybe, right? We do not view the case like that at all. This is a person who has cancer. This is a person who's getting a catheter-related bloodstream infection. So that's the signature injury. So you already have attribution of that bloodstream infection to the catheter, typically in your medical records when you get them. And, any infection for somebody who has a bloodstream infection, for someone who has cancer, that's life-threatening.
Yeah.
At the very least, they're going to have a removal of this port catheter. It just seems to be the standard of care. So that's the situation with the infection cases. And for that reason, I think they're quite serious. They're real cases.
I will say from a marketing perspective, one of the challenges we have with medical devices is very similar to transvaginal mesh is people will raise their hand that they've been affected. People don't know what is implanted in them. The manufacturer, where I had one that had an issue.
Exactly.
So they call in, they see an ad, but they don't know what the actual manufacturer was of that PowerPort or that transvaginal.
You don't know until you pull the record.
I don't know about you. If I have any surgery done and anything's going in, I'm not asking what the brand is.
Yeah. Here's the good news for the people who are marketing is that Bard controlled 70 to 75% of the market since like 2006. And the other company that controlled about 15% of the market was AngioDynamics. Now, my firm is not involved in the AngioDynamics MDL. We are not taking those cases. We're not pursuing those cases. But there are firms out there who are interested in pursuing cases against AngioDynamics as well.
Is it similar injuries, just different manufacturer?
Similar. So our position in the Bard PowerPort MDL is that AngioDynamics actually has one design at least that is a safer alternative design because they made a thrombo-resistant catheter. I think it hit the market in late 2013 or early 2014. And when you have thrombo-resistance, you're going to naturally have some infection resistance there. So they put a better product on the market in the early 2010s.
We're at MTMP, so I have to ask, what is buzzing around that you've heard about that may be something that at least piques your interest that you are thinking about just learning more about and haven't made a decision on yet?
I'm really excited to hear more about these Roblox cases.
We have been hearing
everyone's talking about it.
Some buzz around Roblox.
This is against the minors, right? This sexual assaults.
Yeah, I know the attorneys general are getting involved in it. Some of them have filed some cases already. And I saw it was either today or very recently that I think the Florida Attorney General is looking at not just civil prosecution, but criminal as well. So that's very interesting.
I find it interesting that you bring that one up because I had a play date at my house this weekend. I have a 7-year-old and a 10-year-old, and I do not let my children touch Roblox. I know about all the bad stuff. I do not let them touch Roblox. And I was talking to the other parents, and they're all talking about their kids are all playing Roblox. Mm-hmm. And one of them said, I just can't get it away from her. But she was playing the other day, and she said, Grandma, this person told me to say and do this stuff.
Oh, wow.
And then the grandmother talked to her about what was going on, and it was exactly the fact pattern that we're hearing about, everybody talk about. I'm like, this is way too close to home. Just having people over my house, and there were kids swimming in the pool, we just had the opportunity to talk, and the education that I was able to supply them with to understand, this is not an isolated situation.
Yeah, so I can't imagine. I mean, even just talking about it in our office, right? I know that people have brought up their own stories, exactly like you're doing right now. And so I can't imagine once they get into discovery in this case, what they're going to find about how many parents tried to get in touch, tried to tell them what was going on, and they just looked the other way. I think it's going to be massive punitive damages discovery territory.
Do you think that this encroaches on any of the 230 issues that like the social media litigation?
Yes, we've been doing real well against 230 challenges. And I know that there's a team that's already been put together to look at those issues in this case, and they feel good.
What else at MTMP are you doing here? We're having a conversation, you're learning about other litigations, but what does like a 2-day stint at MTMP look like for you?
Oh man, y'all know Sadie Turner, right? She's the most amazing case manager at our firm, and she works with me on everything. And she comes to this conference, and we split up the schedule. So I'm like, I need to go to this little talk that's going to be happening over here and that little talk that's happening over there. And as you know, there's multiple tracks running at the same time. So one person can possibly attend everything if they needed to. And so Sadie and I divvy up the schedule between what we need to hear, and she'll go take fantastic notes, and I'll run around and do things like talk to you guys, just talk about the Bard cases, make connections with our referral attorneys, sit in on the sessions where I'm able to. I know Mark is talking later today and tomorrow morning. I definitely want to go catch that. That's it. That's what I'm doing.
So 2 questions. For people who want to come to Mass Torts Made Perfect, or it's the first one's coming up, what advice do you have for them to make it a successful trip? You know, it can be very overwhelming. You've been doing how many of these now?
Yeah, a lot.
But what advice do you have for people to get the most out of this?
Oh man, definitely grab somebody who has been and who knows the lay of the land, because there's so much to see and do that it's overwhelming. I'm sure you guys know.
The first one we went to, my head was spinning.
Absolutely. A small firm that does one-offs that sometimes gets in some cases that could be mass torts. Well, then you definitely want to make some connections with people like our firm or people like Pap's firm or whoever, because I think their main goal is going to be able to work with us in a co-counsel capacity, right? And so if that's what they want to get out of it, they need to be, finding us at the talks and making those connections and having people introduce them. For somebody like me, I've got people who I work with on these cases who I want to meet up with and have those meetings. I think it just depends really, what do you want to get out of it at the end of the day? What's your interest here? And you can find somebody who's been here and done that, and they can help you map it out.
If someone wanted to be, in a co-counsel relationship with Lanier, how do they go about breaching that conversation with you?
Yeah, just email me or come say hi, right? My email is rebecca.phillips@lanierlawfirm.com, and I'm happy to talk to anybody. There are no stupid questions, by the way. I have people reach out to me all the time, and they're like, I don't know if this is a good idea or not. You don't have to fully vet the case. I'll do that. That's my job. And we'll just have the conversation about it.
We come across a lot of personal injury attorneys who are asking us as they start to dip their toes into mass torts, like, what should I get into? And I think
the exact language they use. What should I get into?
What should I get into? And I would say that anything that Rebecca is in, that the Lanier Law Firm is in, has been clearly adequately vetted and has great leadership behind it.
A stellar trial team behind it.
That's our advice for you guys watching at home. If you are coming across something, reach out to Rebecca and have her vet it for you.
That's so nice. Thank you, Jon.
Yeah, of course. Of course. Anything that you want to leave our guests with before we wrap up?
Just, thanks for listening, and please do reach out if you want to work with us. We always like to work with good people on good causes, and we're here to help.
Yeah, I would say that's probably like the trend of guests on our podcast too. It's like we just talk to good people. Rebecca is good people. Thank you for watching, and we will see you next time on the Jon and Marc Podcast.
Thank you, Rebecca.